Judge, we're on YouTube. Would you like me to call the case?
Please, thank you.
Yes, ma'am. Calling cause number 2024 DCV 2248, Nisa Cordero et al. Versus Sunrise Restaurants et al. Announcements, please.
Paul Gum on behalf of the plaintiff.
Good morning.
Morning, Your Honor. Moses Winston on behalf of defendants.
Diana Valdez, Your Honor, on behalf of the minor child.
All right, thank you. And we're here for the friendly suit. Is this? I've just got friendly suit here. It doesn't say status hearing. I'm assuming we're going to do a hearing with a record. Is that what we're doing this morning?
Yes, Your Honor.
All right. Okay, the plaintiff may proceed.
Your Honor, before we get started, I want to give you some background on where we're at because I have some inkling and from talking with Mr. Winston that he is going to object to moving forward, but I want to explain what has transpired in the last week.
Sure.
This case settled in early September, at which point we sent an email on September 17th explaining that we would be structuring the net settlement to the minor. At which point we then about last Tuesday sent over the all of the language through our broker to the defense counsel, as well as a breakdown of everything, where the annuity was going to be structured, and asked for a copy of the release and judgment. We did not get any response until Monday of this week. Mr. Winston's assistant sent over a release only, at which point we asked for the judgment, which we got late yesterday. This morning, I got a call from Mr. Winston, and for the first time, I hear that their co-broker, their broker on their side, cannot come to an agreement on the commission split between our broker and their broker. And so Mr. Winston doesn't have approval by the carrier or whoever, because he's saying that because they haven't come to an agreement. Now, our brokers have agreed and sent over a signed commission split this morning after this all became an issue. Everything is ready to move forward. And again, I'm just highly frustrated at the timing of where we're at today since this hearing has been set for so long. And so the total settlement is $1 million. The net is $515,000 and some change to the minor. We feel we're ready to move forward. There's nothing wrong with the structure. Even their brokers have looked at everything. They just have not given final approval. And so I'll let Mr. Winston respond before we call our witness.
Right. Mr. Winston, your position?
Thank you, Your Honor. I think Mr. Gum captured that. I would like to take a little bit a step back even further. When the parties did agree to the settlement, we had a Rule 11 agreement in there, and it says the parties shall co-broker the agreement, right? And so this was always something that we agreed on, and our understanding is that we were going to co-broker any structured settlement. As Mr. Gum stated correctly, I did not receive anything until last Tuesday. No terms. I did not even know who the co-broker was. I immediately sent that to my broker. He, again, from his perspective, he's requested information, not only on the commission, but also we need information to verify the annuities. We've asked for the prudential term sheet, which again, we got at about 30 minutes ago, 40 minutes ago is when my broker first got that. And so I agree, the parties are not ready, Your Honor. We have not been able to approve this. I will take my part in this, but I also think there is a lack of communication between the brokers. I'll also say, Your Honor, we didn't get the GAL report until last night. And so all of this is just very contracted in terms of what we need to do to verify this before we broker, which is what the parties agreed to in a Rule 11 agreement. And so I understand this is frustrating to push this back, but I think it is necessary, Your Honor, to ensure that my client is able to perform the due diligence needed. Again, we did not get this until 30 minutes ago here, Your Honor. I don't think that's sufficient for us to be able to do. I know it's not sufficient for us to do our part here. I don't think it'll take much longer than this week, but as far as me trying to get this before the hearing today, just not able to get it. And that's certainly not, the situation was created by both sides, I believe, with the brokers not being able to communicate and provide the necessary information.
Okay,
Your Honor, if I can just correct a couple
Yeah.
of things, because that's
Sure.
not entirely true. Our Rule 11 said that they're allowed to co-broker. We sent over everything. We didn't hear about a co-broker until this morning. In terms of what everything was exchanged between the brokers, other than our brokers did all the work. All of the language and everything is our work. The fee split was the only thing that didn't align. And so all of the work has been done. And so again, the frustration lies with, we don't need that broker. We've already, they're going to get a release. The defendants will be released. Any recourse my clients wouldn't have against them. We're ready to proceed. And the ad litem is here to recommend approval of the settlement. And so again, just highly frustrated with the timing and lack of communication. And there's no need that we need to push this hearing.
So, I mean, I think obviously one of the things we could do, the court can do is listen to the testimony, withhold judgment a week until you guys, I guess my real question is it your understanding or do you anticipate that the co-brokers are going to come to some agreement on the commission split, or is that or is that going to be resolved, or has it been resolved, or is it not resolvable? I guess that's my question.
It has been resolved. So
Okay.
this morning,
So
I
now
will-
we're just talking about paperwork.
Yes.
Not exactly, Your Honor. I think the proceeds is also something. That's the term sheet. My office or my broker needs to look at that and look at the structure, right? And so I agree. I don't think that's going to be a problem, but it's not. The commission is done. I just received that again at 10:34. My broker needs to check all of the projected payments. We again did not have this information until this morning, and I just requested the term sheet be sent to my broker, and so that has been sent. But again, trying to get that done right now is not going to be is not available. I only see one plaintiff here, Your Honor, and so I mean, this is a case between both plaintiffs on behalf of their child, and so if to the extent we're handling witnesses and finalizing this today, I certainly need Mr. Galvan to be here, and I anticipated him as a witness as well to finalize.
Your Honor, both Mr. Galvan and Ms. Cordero are signatures to the release. They have, and Ms. Cordero can testify on behalf of the recommendation. Mr. Galvan was involved in everything, and he's working right now.
Yes, currently he's here. He's just been in the room with the
Okay.
kids trying to settle
Okay.
them down. But I
All
just
right.
passed them over.
Okay.
Okay.
All right. Well, hold on. So both the witnesses are here. So how about if we take testimony, and we get all of that out of the way, and we could set you for, I'm going to call it an entry of judgment hearing, maybe in a week to 2 weeks, so that the paperwork can follow. I don't. Does anybody have any objection to that?
No, I think that works.
No, Your Honor, I think that'll work.
All right, Ms. Valdez, you've been quiet.
Yes.
Do you have any objection to the court going forward that way?
No objection at all, Your Honor. In fact, it's my preference for us to proceed. I feel that that's in the best interest of the minor child today. I'm like Mr. Gum, was disappointed to hear this information. I mean, I'd hate to see the child prejudiced and for there to be an unnecessary delay because a commission split cannot be agreed upon. So it's my understanding that that's occurred. It's also my understanding that the settlement amount has been agreed to by the parties. And, I received a copy of the structure that set forth all of the numbers and the way that this would fund for the benefit of this child, who, unfortunately was significantly injured as a result of the incident in question here. And so it's my preference to proceed and provide my recommendation this morning in accordance with the needs of that child.
All right. All right. So we'll do that. Let me hear the evidence, and then like I said, we'll have the court coordinator set us something as an entry of judgment, 7 to 14 days or as the court's docket permits, which I don't think that should be a problem to do that.
Thank you.
You're welcome. Mr. Gum, you want to go ahead and call your first witness?
Yes, Your Honor. We'll call Nisa Cordero.
Ms. Cordero, can I get you to raise your right hand for me, please? Do you solemnly swear or affirm that the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay, you may proceed.
Can you please state your name?
Nisa Cordero?
And Mr. Cordero, you are the biological mother of Brody Galvan, correct?
Correct.
And on October 21st, 2023, you and your family, including Brody, were at Denny's in El Paso when a cup of hot coffee was placed within reach of Brody, who was 10 or 11 months of age at the time. He ultimately grabbed that coffee and poured it on himself. Is that correct?
Correct. He was 11 months at the time.
And from there, you and Johnny and your other son ran to Del Sol Medical Center, where Brody was initially treated, and then he was flown from Del Sol to Lubbock to the burn unit. Is that correct?
That's correct.
And he stayed a couple nights there, received some wound care, and then was ultimately discharged and told to for you to basically take over all of the wound dressing, correct?
Correct. Yes.
And there is still some slight discoloration of the skin on Brody, but other than that, his physical injuries have healed. Is that correct?
That is correct.
And you hired our firm to bring those claims on behalf of Brody and yourself and Mr. Galvan against the Denny's. Is that correct?
Yes, that's correct.
And after filing this lawsuit and prolonged litigation, we also ultimately reached an agreement with Denny's to resolve Brody's claims for $1 million, correct?
That's correct.
And you understand that by accepting that amount or recommending that the court approve that amount, that you are settling all of the claims involved in this case on behalf of Brody, and he'll never be able to bring those claims again. Do you understand that?
Yes, I understand.
And you understand that you can't come back and ask for more money if something were to occur related to the burns, correct?
That's correct.
And out of that $1 million, we have to pay attorney's fees, there's case costs, as well as reimbursing Medicaid. Do you understand that?
Yes.
And you understand that we have reduced our fee from 43% to 40% in order to put a little bit more money in Brody's pocket, correct?
Correct.
And so our attorney's fees would be $400,000. The case costs are $73,165.83, and we will be reimbursing Medicaid payments of $11,590.71. Do you understand that?
Yes.
You understand that that leaves Brody with $515,243.46, which we're going to put into a structured settlement annuity for his benefit.
Yes, I understand.
And you understand that annuity is going to be purchased through the Prudential Insurance Company, which will pay him $3,616.68 per month for 40 years and the rest of his life thereafter, correct?
Yes. Correct.
And on top of that, there will be guaranteed lump sum payments of $25,000 when he turns 18, $25,000 when he turns 21, $25,000 at 23, $50,000 at 25, and $100,000 at age 30. You understand that?
Yes. Yes, I do.
And so you understand that the $515,243 that will grow, and the total guaranteed payments out of this annuity is $1,961,006. Do you understand that?
Yeah. Yes.
And knowing all of that information, do you believe that settling these claims and moving forward with this structure is in the best interest of Brody?
I do believe.
And do you are you requesting that the court approve that settlement?
I am requesting. Yes.
Thank you, Nisa. I have no further questions.
Thank you.
Mr. Winston?
Yes, Your Honor. Thank you. Ms. Cordero, can you hear me okay?
Yes, I can.
Great. Nice to see you again. Ma'am, I'm going to go over a few questions here. I'll try not to duplicate what Mr. Cole or Mr. Gum has said, but let me get through a few of these questions regarding your settlement, okay?
Yes, sir.
All right, ma'am. Can you please state your name and date of birth?
Yes, my name is Nisa Cordero. Date of birth is 02/14/1998.
And Ms. Cordero, what is the date of birth of the minor child subject to the settlement?
It is November 16th, 2022.
Ms. Cordero, we met before, but do you understand that I represent defendants Sunrise Restaurants doing business as Denny's and Andrea Rodriguez or Daniela Rodriguez as defendants in this lawsuit you filed?
Yes, I do, sir.
Okay. And Ms. Cordero, are you the minor's legal guardian?
I am.
And you answered this, but you are aware that Brody Galvan is entitled to $1 million for his portion of the settlement as a result of his claims related to the incident set forth in your petition, right?
Yes.
Okay, and you've agreed to this settlement on behalf of Brody?
Yes, sir, I have.
And Ms. Cordell, do you understand that Brody may have suffered damages that are related to the alleged events in your petition that you're unaware of today?
Yes.
And do you understand that significant disputes exist regarding liability for the damages and that Brody may have sustained?
Yes, I do.
Okay. And Ms. Cordero, do you understand that you had a right to take any of these claims on behalf of Brody for the damages arising to trial and have them heard by a jury?
Yes.
And are you also aware that if the case did go to trial, the result from the trial could have been an award that was either higher or lower than the settlement amount that you've agreed to today on behalf of Brody?
Yes.
And do you understand that all claims that you or the minor child could have brought, or can bring in the future that relate in any way to the injuries or any other damages alleged by Brody to have sustained as a result of the events alleged in your complaint are now permanently extinguished?
Yes, I do.
And Ms. Cordell, do you understand that the settlement funds set aside for Brody are the sole and exclusive benefit for Brody?
Yes, I do.
Okay. And do you understand that the settlement agreement you have entered into with defendants on your behalf and on behalf of your minor child that relate to any damages Brody may have alleged or sustained resolves any claims that you or Brody may have brought or can bring against defendants as a result of this incident?
Yes, sir.
Okay. And Ms. Cordero, have you reviewed the proposed settlement with the guardian ad litem?
I have.
Okay. And do you want the judge to approve the settlement?
I do.
Okay. Thank you, Ms. Cordero.
Yes, thank you.
Ms. Valdez?
Yes, Your Honor, thank you. Good morning, Ms. Cordero.
Good morning.
So, Ms. Cordero, during the course of this matter, you and I have had an opportunity to visit to discuss your son, Brody, correct?
Yes, correct.
And during that time, we had an opportunity to discuss the specific details that led to the incident that caused injuries to Brody, correct?
Yes, correct.
And we also discussed his progress, his development, and how he's done since this incident occurred, correct?
Correct.
Okay. And you've indicated to me that based on your observations, developmentally, he appears on track, correct?
Correct.
And he's grown now to be a 3-year-old, very happy and active child, correct?
Yes, he has.
Okay.
Yes.
Yes. And ma'am, we also discussed the proposed annuity that would essentially serve as the vessel for housing the settlement proceeds on behalf of your son, Brody, correct?
Yes.
Okay. And we discussed the length and essentially your wishes in terms of how that funds over the course of his lifetime, correct?
Yes.
And based on that discussion, as well as your personal knowledge of raising Brody, you believe that this settlement is in his best interest, correct?
Yes, correct.
Okay. And you further understand that in the event he has medical issues down the road, that by settling this matter, there will be no further opportunity to obtain further, for example, medical expenses on his behalf against the defendant in this case, correct?
Correct.
Okay. And you also know you have the right to go before a judge and a jury to ask for more money than what's being settled upon today, correct?
Correct.
Okay. But based on that information, it's your decision to recommend to Judge Rodriguez that the settlement be approved and accepted on behalf of your son, Brody, correct?
Yes, that is correct.
Okay. And Judge Rodriguez, as soon as the remaining details regarding the commission split are effectively resolved, I will be providing a detailed report with my recommendations that also lays out the annuity terms and the sums that will be paid, as well as to provide the court an update with respect to Brody's recovery.
Thank you. We appreciate that.
Thank you, Judge.
You're welcome. Mr. Gum, your next witness.
Yes, we will call Johnny Galvan.
Mr. Galvan, can I get you to raise your right hand, sir? Do you solemnly swear or affirm the testimony you're about to give in this cause is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you. You may proceed.
Can you please state your name for the record?
Johnny Aaron Galvan,
And Mr. Galvan, what is your date of birth?
September 10th, 1994.
And you are the biological father of Brody Galvan?
Yes, sir.
And you are a legal guardian of Brody Galvan?
Yes, sir.
And you heard my questions of Ms. Cordero, correct?
Correct.
And you understand the terms of the settlement as outlined in those questions?
I do.
And you understand that by accepting this settlement, Brody can never come back and ask for more money, or you both will not be able to do that, correct?
Correct. Yes.
And you understand that you could have went to trial, you could have been awarded more, you could have been awarded less, and instead you've chosen to resolve these claims, correct?
Yes.
And knowing what you know about Brody's injuries, do you believe this is in the best interest of him?
I do.
And are you asking the court to approve the settlement?
Yes.
Thank you. I have nothing further.
Mr. Winston?
Thank you, Your Honor. Mr. Galvan, can you hear me?
Yes.
All right, sir. Thank you again for being here. I'm going to jump around just like I did with Ms. Cordero. Can you, do you understand? I know we met before at your deposition. Do you understand that I represent the defendants in this matter?
Yes, I do.
And are you also aware that are you also Brody's legal guardian in addition to his biological father?
Yes, I am.
Okay. And Mr. Galvan, are you aware that Brody is entitled to $1 million for his portion of the settlement as a result of his claim related to the incident that's set forth in your petition?
I do.
And have you agreed to this on behalf of your son?
Yes.
And do you understand that Brody may have suffered damages that are related to the alleged incident that you're currently unaware of?
Yes.
And do you understand that there's a significant dispute regarding liability for the damages that Brody may have sustained?
Yes.
And are you aware that, or do you understand that all claims that you or Brody could have brought or can bring in the future that relate in any way to this incident or the injuries claimed are now permanently extinguished?
Yes.
And do you understand that the settlement funds set aside for Brody are for the sole and exclusive benefit of Brody?
Yes.
And have you reviewed the proposed settlement of the guardian ad litem?
Yes.
And do you want the judge to approve the settlement?
Yes, I do.
All right. Thank you, sir.
Thank you.
Ms. Valdez?
Yes, Judge. Good morning, Mr. Galvan.
Morning.
Okay. You understand that I've been appointed to represent the interest of your son, Brody, correct?
Yes, ma'am.
Okay. And is that Brody situated right behind you on camera?
Yes, ma'am.
Okay, very good. Mr. Galvan, you've had an opportunity to observe your son and his progress since the accident?
Yes.
Okay. And it's your position that the settlement that's been reached tentatively between the parties is in Brody's best interest?
Yes, ma'am.
Okay. And you, along with Ms. Cordero, have had an opportunity to review the proposed annuity at length in terms of how this particular fund will benefit your son in the future?
Yes, ma'am.
Okay. And you understand that those funds will be paid to him over time in various payment amounts and lump sums?
Yes, ma'am.
Okay. And Mr. Galvan, are you asking the judge today to approve the settlement on behalf of your son?
Yes, ma'am, I am.
Okay, very good. And you believe ultimately that this is in his best interest, correct?
Yes.
Okay. Nothing further, Your Honor.
Thank you. Anything further from anybody?
Nothing further.
All right. Pending the submission of the documents and the agreement on those documents, I'm gonna tentatively approve based on the evidence that I've heard. So I'm gonna ask the court coordinator, Myrna, to set y'all if we can. I'd love to be able to set you for next week for an entry of judgment, and that's generally fairly easy. But if for whatever reason, I don't know, Myrna, I know you're right there. Is that possible or the following week?
It's not possible for next week, Judge. It would have to be the 2 weeks.
Okay.
So we're looking at November 19th.
Okay.
First thing in the morning, 9:30.
All right. All right. Anything further from anybody?
Nothing further. Thank you, Your Honor.
No, you're very welcome. Good luck. Yeah. Good luck to y'all.
Thank you.
Okay. Thank you,
Okay.
Judge.
You're welcome. Bye-bye. You're adjourned. You're dismissed.